Yes, good evening to everybody. Welcome to the class of the family law that I am dealing the Muslim law. Yesterday class that I dealt the gift, and this class that I am going to deal the wasihat. Will, yes, read what I posted on the screen.
Namaskar Vargul, good morning. Will Vargul Wasiyat under Muslim law. Virtual class Professor Dr. M.S. Hussain.
Yes, and now let us deal the will. The will, what is will? Any idea? What is meant with the will?
The propositus writes his property to whom it goes. It is called, after his death, is called a will. Sir.
Any person who is competent enough and who is the owner of the property will write a will not more than 1/3 towards the anyone to whom he likes, including the stranger, in the form of a will. But this will be devolved upon only after the death of the propositus, that is the person who died. That is called testator. Is it clear? Yes.
Sir.
So a concept of the will under the Muslim law, let us see it. A will, or we can say a testament, or we can say wasiyat, has been defined as, I quote, an instrument by which a person makes a disposition of his property to take effect after his death. I repeat, it is an instrument, it is a document, it is a paper by which a person who writes it makes a disposition, means transfer of his property to take effect after his death. He can transfer his property after his death. But how a man will transfer the property after his death? Automatically somebody will take care of and see that the property will be transferred, disposed to the other people. Tayyab ji. Who is Tayyab ji? Yes.
Sir.
Who is Tayyab ji?
Author.
Author. Yes. The Tayyab ji defines will as, I quote, conferment of right of property in a specific thing or in a profit or advantage or in a gratuity to take effect on the death of the testator, I unquote. According to Tayyab ji. Conferment means giving, passing of what? Right. On whom? Property. In a specific thing, means in a specific property, or in a profit, or any profit like usufruct, I told you, harvest, or advantage, I told you the actionable claims, or in a gratuity to take effect, or something like a sadaqah which he wants to give to it on the death of a testator. But the sadaqah will be given by the person who is alive. Is it or not?
Yes, sir.
Yes. So it is death of the testator. Testator means a person who is going to write a will is called a testator. A person who did not write a will is called did not write a will is called
Interviewers, sir.
Interstate. The distinguishing feature of a will is that it becomes effective after the death of the testator and it is revocable. But here we will say testator in the will. But there in the inheritance we can say prepositus. Is it clear?
Yes, sir.
Yes, sir.
Good. So, unlike any other disposition, what is this? Unlike any other disposition, what is this?
Example.
Example, EXAMPLE. Example. What is this EG? If you know it, you tell me. If you don't know it, pass on. I will give the answer.
Pass on, sir.
Exempli gratia. EG means exempli gratia. That means, for example, E full stop G full form. Then I'll show you. Of course, in the middle, nobody will write the capital letter. It is only the small letter, full stop, G small, is the short form abbreviation for the exempli, EXEMPLI, exempli gratia, GRATIA, which means, for example, or in a bigger manner, in the beginning, we will write the example E capital letter, XAMP, or we write E and full stop and G full stop. Used before an item or list of items that serve as an example for the previous statement. Feel free to print this out and post it wherever you need it. For example, we write EG because we purchased ice cream. EG, exempli gratia. For example, how many flavors are there in ice cream? Sir, we did not eat, sir. We don't know, sir, how many flavors are there.
Butterscotch, mango, strawberry.
Vanilla. Which one is costly? Which one is costly? Depending on the quality. No, butterscotch is costly. Of course, I don't eat, but my children will eat more. But my wife will eat more. Okay, EG means exempli gratia, sale or gift. Within, this is within. Professor Hussain will not, Professor Hussain students say, within this thing. Yes? Within, what is this?
Exempli gratia.
Yes, it is in what is this here highlighting? I'm highlighting.
Braces.
Professor Hussain
Braces.
students never say in that way. Parenthesis.
Parenthesis.
Don't say round bracket. Don't say curve bracket. Parenthesis. The testator exercise full control over the property bequeathed till he is alive. Here word bequeath is. Bequeath means devolving upon somebody else. That is called bequeath. Bequeath word you use only for the will. But devolve you can use only in the inheritance. Prepositors you use only the inheritance. Testator you use only in the will. Are you following me?
Yes, sir.
Yes, sir.
Alive, colon, the legatee or beneficiary. Who is the legatee? Who is the legatee? Sir.
Beneficiary, sir. Beneficiary.
The person
Heir.
who is going to get the property after the death of the testator means beneficiary. The legatee or the beneficiary under the will cannot interfere in any manner whoever in the legatee's power of enjoyment of the property, including the disposal of the transfer in the case of will becomes revoked. Till the testator alive, the beneficiary could not do anything. That means the property should be after he will get it only when the testator is no more. Is it clear? Object and significance of will. So the object of the will, according to the tradition of the prophet, is to provide for the maintenance of members of the family and the relatives where they cannot be properly provided for by the law of inheritance. Do you know why this is a mechanism of will introduced in Islam? Quran, there is no citation in the Quran. There is no clear-cut citation. Of course, Surah Nisa is there, but not directly involved over there. Surah Nisa. And but here they say, heirs definitely they will get it after the death. But some people, those who helped him or her in his brought up or in his grown up, and such person, he would like to give some portion to that people also, because that people also deserve it. Because number one, they are not relatives, they are neighbors, number one. Number two, they are poor. Number 3, they are very much compassionate, and they are very much helpful to them in their children, wife, or for himself, or many other means. So in such a time, the Islam says give something to them also, because they served you, even though they are not the. You know that at the time there is a slavery is there, is it?
Yes, sir.
And we will say in that slaves bandi, especially that bandis are women. Of course, the men also be there, slavery. They used to do it. And you know, bandi, she will work in the house. And moreover, if the bandi also do BBC with the owner, with the landlord. And the children born to them is a legalized children there, because it is he who take care of them. And in case he will not adopt, acknowledge also, and give the share as if they are own children. Either this thing, or he is having kind enough to give something to other than the heirs. So that equation has come over there. This is the will. The object of will is, according to the tradition of the prophet, is to provide for a maintenance of members of family and other relatives where they cannot be properly provided by for the law of inheritance. In the law of inheritance, they could not get it because they are not the relatives. They are very, very distant kindred, or more than distant kindreds. So the prophet said, no, they do also have the share in our property. Better you give something to them, either in the form of a sadaqah, or in the form of a ariyat, or in the form of the khura, or in any other form, but give something to them. So that concept has come through the form of the will. But some people said, prophet said, because the contemporary name I have forgotten. At the time I remember Ruh or Ruh. And one contemporary asked the Prophet Muhammad, sir, I have a lot of property, and I do have to give something to in the form of a will. Then how much I could give in the form of a will? And he said, can I give 3 by 4th? Then Prophet Muhammad said, no. Can I give half? Then the Prophet said, no. Then I give 1 by 3rd. The Prophet Muhammad said, okay, okay. In that way, that he did not say yes, he said okay, or something he gave the sign. So 1 by 3rd you are supposed to keep give in the form of a will, but the 2 by 3rd you should be given to the yes,
Yes.
legacy heirs, because when you see what are the deductions for the inheritance we saw, what are the deductions? Number 1, sir, buying the shoe.
1 by 6 mother, sir. 1 by
Number 2,
number 2.
సార్ మొన్ననే చదివినాం సార్, మొన్ననే మర్చిపోయినాం కదా సార్ మేము. We studied and we buried there. Number 1, funeral expenses or funeral expenses. funeral. How do you pronounce?
Funeral.
Okay, funeral expenses. Number 2,
Oh, debts, sir. Debts.
that's number 3,
Will.
wills, legacies, and whatever the property
Yes.
would be left over there, the remaining property we devolve upon inheritance. So that is the whole idea. So after the legacy paying, only the inheritance comes over there, and inheritance comes to the legal heirs in Sunni law. Next, Quranic heirs. Next, neighbors. Next, pedestrians. Next, railway
Distant
passengers.
Residue is distant kindred, sir.
Why you are taking that much time? See, we discussed at least gift to 4 days. Okay, let us come to that. At the same time, the Prophet has so declared that the power should not be exercised to the injury of the lawful heirs. The reason they said, if you want to give one half to the other people, then what will happen to your wife and children? They will be on the roads. So a bequest in favor of an heir would be an injury to the other heirs. So it would be reduce the shares and would be consequently induce the breach of ties of the kindred. So better you say, instead of giving 1/3, you try to reduce it so that your wife and children will enjoy the more. So thus, the policy of the Muslim is to permit a man to give away the whole of his property by gift inter voce. But the gift you can give as much as you can, but it is only theoretically. But to prevent him, except for the 1/3 of its estate from the interfering by will. So will, they say, no, you are supposed to give 1/3 only, at the most, with in the course of the devolution of the property, because the legal heirs and are equally held responsible. In addition to the legal heir, they do other residues and distant kindred also there, because they also expect something from you. A will offer to the testator the means of the correcting to a certain extent the law of succession and enabling some of those relatives who are excluded from inheritance. So some of the poor relatives, they are excluded from the inheritance because when the mother is there, the grandmother will not get it. When a father is there, the grandfather will not get it. Is it or not? When the two sisters are there, then son's children will not get it. Son's daughter will not get it. We read, we did it. And enabling, so some of the people, they did not get the inheritance. To make them happy, this is the form of equation with that some property will be given to them. And that is the idea behind the will. And moreover, they don't want to make any disturbance also. After the death of the person, testator, they should not be in a debt. See, this property goes to the so-and-so, this property goes to the so-and-so, and this property where I'm staying till my death, I am the owner of the property. Once my death is over, then it goes to the so-and-so person. They clearly write the will, and they will see that it will be signed by the two witnesses and got it registered by the, as usual, like house, land registry. Now it is going to Tahsildar, I believe. Yes. Formality of a will. As a general rule, no formality is required for making a will. You can make on a plain white paper. You can write it. House goes to the so-and-so daughter or son. Bank balance go to the so-and-so. Gold goes to the so-and-so. Then any other field goes to the so-and-so. Over. Sir, in the will, when you are writing it, whether the people, those who are there, they should have agreed or not. No. It is his choice, testator's choice, to give how much he wants. It is not the legal heirs. It may be anybody else. Okay, including the legal heirs also. Are you following me?
Yes,
Yes,
sir.
sir.
Yes. No writing is necessary to make a will. No. Always keep it in white and black. It is a valid will. And no particular form. Form is not, there is no, you can just write the way that you want to write it. But what you write, you should do, you should supposed to read it and understand it. Then only you can make it, execute it. By keeping the signature or by keeping the thumb impression with the two witnesses should be present over there. So, where the will is reduced in writing, it is called Vasiyat Nama. Vasiyat will. Nama, document. Like Agadnama, Panchanama. Are you following me?
Yes, sir.
Very
Yes,
good.
sir.
So, Vasiyat Nama, that is say, it is in writing, it need not be signed, it does not require the attestation. If it attestation, there is no need to get it registered. Better you keep the attestation, better you keep it in writing, and better you register it. Because to avoid the further complications. Okay? Yes. Shall I proceed?
Yes, sir.
Very good, very good. Instructions of the testators written on the plain paper are in the form of a letter and in the clear-cut terms provided for the distribution of his property after his death would constitute a valid will. Nearly on white paper, if you say this property goes to so-and-so, this property goes to so-and-so, it is enough. It is a common will, provided it should not be more than 1/3 of the entire property. In case a will is a oral, the intention of the testator should be sufficiently ascertained in comparison to the will in writing, which is easier to prove. So always put it in black and white. That is always safe side instead of keeping the oral, because sometimes even a man can break his oral promise. The burden to prove our oral will is very heavy, and it is very difficult to make it out and takes a lot of time, and hence better whatever you want to do it in a white and black way. Okay. Requisites of a valid will. What are the requisites of the valid will be there? Number one, you read this you read one after one another.
The testator legator must be competent to make the will. Second one, the legatee testatrix must be competent to take the legacy on bequest. Third point, the subject property of bequest must be a valid one. Fourth point, the bequest must be within the limits imposed on the testamentary power of a Muslim.
Just number one bullet, the testator means the person who is going to give the write the will is called the legator also. Must be competent. What is meant by competency? He should be more than 18 years. Number one. Number two, the sane mind, and he should not be senile to make it the will. Yes, that is good. Number two, the legatee. Within parentheses, they say testatrix. Testatrix. Testatrix means female. Legatee is a male or a female, doesn't matter. But testator male, testatrix female, must be competent to take the legacy or bequest, because the person who is going to receive the property should also be competent to take the legacy or bequest. A minor cannot take it because he could not make a contract here or can receive it. The third bullet is the subject within parenthesis, that is the property of bequest must be valid one, because it should be in existence, it should not be legal one, the ownership should be there, and the valid one, the subject of the property, which is going to give in the form of a will. And the last bullet is the bequest must be within a limits imposed on the testamentary power of a Muslim. That means he should have capable of executing the bequest. That would be a valid bequest, and the property belongs to him. Number one, he is having the competency. Number two, and the property should be in existence when he was going to die. At the time, the property should also be there. Then only the gift, will be executed in proper manner. Yes, testator and his competence within parenthesis, who can make a will. So here, every major Muslim above 18 years of sound mind can make a will. The age of majority is governed by the Indian Majority Act of 1875, under which a person attains the majority on the completion of the 18 years or the completion of the 21 years if he is under the supervision of the Court of Wards Act. Thus, the testator must be of the 18 or 21 years, as the case may be, at the time of the execution of a will. Okay? At the time of the execution of a will, within parentheses, that is, id este, i.e., when it is being made, the testator must be of sound mind. Yes, he should not be insane, and he should not be in the convulsions at the time when he is executing the will. Under the Muslim law, the legator means the person who is going to make the will must have a perfectly disposing mind, means sound mind. That is, i.e., id este, that is, the legator must be capable of knowing fully the legal consequences of his activities, not only for a brief period when his declaration was made, but much after that. That means he should know that what he is doing at the time, and he know the repercussion of it, he know the consequences of it, and everything he should know it, and is a sane condition. If he is executing a will, yes, that is a valid will. A will that is executed in apprehension of death is valid, but under the Sharia law, if the person executes any will after the attempting to commit a suicide, the will is void. There is a little difference is there. A will that is executed in apprehension of death, that is at the time of the deathbed, if a person could have made the will, yes, that is a valid will. Under the Sunni law. But under the Shia law, if a person executes any will, okay, after attempting to commit suicide, of course, first he executed the will, later on he committed his suicide. After committing to commit suicide, they say the will is void. I don't know this because once he executed it, later he died. That they say that it is a void will under the Shia law. A minor is incompetent to make a will. Yes, it's obviously everybody knows it, and such a will is a void. But a will made by minor may subsequently be validated by his ratification on attaining the majority. Yes, that is also be there. But a will made by minor may subsequently be validated. Of course, he made it, but later on he validated when he attained the age of 18 years. But such a will is a valid will. Is it okay?
Yes, sir.
Good. A will procured by undue influence, coercion, fraud is not a valid. Under which section these are given under the Indian Contract Act? Undue influence, coercion, fraud. Is it 13, 14, 15, 16 or 14, 15, 16, 17? It is one sequence is there, undue influence, coercion, fraud is there, that is not a valid. And the court takes a great care in admitting the will of a Pardhanashin lady also. Even a Pardhanashin lady, means secluded lady, if it executes a will, there also doubts are very much there. So a thorough check would be there for the Pardhanashin lady who executed such a will. Thus, a will must be executed by a legator with the free consent, yes, no coercion. I told you one dialogue. I don't know whether you remember it or not. Kanta mida betti revolver vettadam. Say in English. Yes.
Temple.
Keep the pistol on temple.
Zero range on the temple. Zero range on the temple means on the temple we keep it. So keeping the zero range, the revolver on the temple, and if a will would be executed, there is not a will which is given the free consent. The legator must be a Muslim, and at the time of the making and execution of the will, a will operates only after the death of the legator, before his death. It is simply a mere declaration on the basis of which the legatee may get the property in future. A legator, suppose he wants to give the will, he can give it. Can a non-Muslim can also a legator? Yes?
Yes, sir.
See, it doesn't matter if anybody wants to give that. A non-Muslim wants to give the give in the form of a will to somebody else. Then if the other person accepts it, then why the court will interfere? You are a non-Muslim, you are giving to the Muslim. Can the court will interfere? Answer no.
No, sir.
Sir.
Yes. If a will has been executed by a Muslim who ceases to be a Muslim at the time of his death, the will is a valid under Muslim law. I repeat, if a will has been executed by a Muslim who ceases to be a Muslim at the time of his death, will is a valid under Muslim law. Even though will is there, but at the time of the death, he was no more a Muslim. But at the time, still, it is a valid will. So also the will is governed by the rules that of school of Muslim law to which the legator belonged at the time of the execution of the will. But at the time of the execution of will, what is the religion of the person? If once the execution started, meanwhile the legator died, of course after the death of the legator only this will start. Is it or not? Say yes.
Sir. Yes.
For example, if the legator was a Shia Muslim, okay, at the time when he wrote the will, okay, good, only Shia law will is made applicable. When he wrote the will, he was a Shia, then Shia law would be applicable. Of course, once he wrote the will and later he died, but at the time of the death, before the time of the death, he converted into another Christian religion. Doesn't matter. Because he executed the will at the time when he was Shia. Are you following me?
Yes,
Say
sir.
yes.
Yes, sir.
Legally and his competence to whom will can be made. If any person capable of holding the property, that is a Muslim, non-Muslim, insane, minor, a child in the mother's home, etc., may be a legatee. Who are the legatees? Tell me. Who are the legatees?
Who takes the will? Who takes the property?
Who are they here? Who are they here? Muslim, non-Muslim, insane, minor, a child in the mother's womb. చెప్పాను కదండి అక్కడ కనబడితేనే ఉన్నది అక్కడ. Is it not visible?
Yes, sir.
But why you are not giving the answer? Sir, we thought you are asking some different things, sir. Because we know that you did not answer small things. No, I will ask anything. So, under a will, there's sex, age, creed, caste, religion, faith, no bar to the taking of a bequest. But giving, yes, there is a bar. If once he is a Muslim, he gave, okay, no matter. But once he changed another religion, he cannot supposed to give. Is it clear? Say yes. Because the
Yes,
Muslim
sir.
law will not be applicable to him. If he renounced the Islam, then naturally he is accepted as the Hinduism or the Christianism or Buddhism or Jainism, then Muslim law will not be applicable to him. Agreed? Say yes.
Yes, sir.
Okay. Ligati. Yes, read. You read. I want to make you busy also. Read. Read what I highlighted.
Legatee within parentheses, including a child in its mother's womb, must be in existence at the time of making of the will. Thus, a bequeath to a person unborn person is void.
But when at the time of the writing the will, the legatee means a child in the womb should be there. But he will get only at the time he has to take the birth and viable at least 48 hours. Then he will be entitled for the will. Otherwise, it is not a valid will. A bequest to person, unborn person is void. No. Because viable, born and he died later on after 48, yes, he will be entitled. But stillborn, no. Stillborn means by birth taken place with a dead person. No, that is called stillborn, not valid. A bequest may be validly made for the benefit of a juristic person, like a church, like a masjid, like a temple, or any personality, juristic person, or an institution, schools, hospitals, but it should not be an institution that promotes a religion other than the Muslim religion. Suppose it should not be given to the Christian religion, it should not be given to the Hindu religion, because it is a Muslim will is there. Hence, in that faith people, it can be given. So, not is against Hinduism or Christianism or Jainism should be not be given that property. A bequest for the benefit for the religious or charitable object is valid. Yes, we can give that in the form of a will to the charitable purposes and the religious things, the bequest, like we are giving the waqf. It is unlawful to make a bequest to benefit an object opposed to the Islam. Yes, it is opposed to the Islam. You are not supposed to give it. Otherwise, it is about to a not a valid will. An idol in Hindu temple or church or idol worshippers or who is opposed to Islam, they are not supposed to give it to them. It is clearly mentioned. No one can be made the beneficial owner of the shares against his will. I repeat, no one can be made the beneficial owner of the shares against his will. Because owner's shares are shares, no one can question it. Therefore, the title of the subject of the bequest can only be completed with the express or implied consent of the legatee after the death of the legislator. Say, if a will is given over there, it is a choice of the testator to accept it. Sorry, legatee to accept it, not to accept it. Of course, he is a minor, but once he emancipated, or means majority attained over there, then he can relinquish it or he can repudiate it, the gift, not gift, it is a will. He'll change the will. He will return the will. He will not accept the will. The legatee has the right to disclaim. He is having every right to either to accept it or to
Reject it.
reject it. A person who has caused the death of the legator cannot be a competent legatee. Explain. Explain.
A person who causes death to the legator means who kills the legator. He is not competent. He cannot take the property of the legator.
He cannot be a legatee because intentionally he killed the legator. So he is a disinherited or he is not competent to get it. A will operates only after the death of the legator. Therefore, a greedy and impatient legatee may cause the legator's death to get the properties immediately. ముసలుడు చచ్చిపోతాడు కదా ఇంకా బతుకుతాడు కదా. So if he does so, then naturally he will forego it. However, it is also immaterial whether the legatee knew about him being a beneficiary under the will or not. Suppose he doesn't know whether he is a beneficiary or not. Doesn't matter. Doesn't matter. Any person who kills, later on he came to know he is one of the person who is the beneficiary. Subject matter of the will, that is bequeathable property and its validity. The testator must be the owner of the property. Like I told you, one cannot give the gift Taj Mahal to anybody. Is it?
Yes, sir.
See, today I saw one viral in WhatsApp. The two very intelligent people, and they found one sheikh, means Saudi Arabian person, thinking that Saudi Arabian person doesn't know that much, the knowledge he doesn't have it. And because he knows only Arabic very much, but English very less, provided he is a very educated man. So these two people intelligently sold the well to the Arab man. The Arab man paid the money. You know well, Bavi.
Yes, sir.
Did you get my point? Did you understand what is Bavi? Well, Kuwa.
Yes, sir. Well, sir.
Then the two intelligent men said to the Arab, no, we sold the well, but we did not collect the water. We did not sell the water to you. The water cost also you have to pay us. We sold the well, but we did not pay. You did not pay the cost of the water. So we would like to sell the water cost also. Then yes, I understand very well. Yes, I paid your well. I did not pay for your well, that is the water. Now, if your water would be there, I will charge the rent. You take away the water. If the water would be there, I will charge the rent. Please, you take away the water from the well. Then who is intelligent?
Saudi Arabian was intelligent.
Saudi Arabian is intelligent. Can he take away the water from the well? If you go and take it, there is a just water there, because the springs are there in the lower state of the springs are there, fountains are there. So don't show intelligentsia, because other people also equally intelligent. Don't underestimate it. Is it clear?
Yes, sir.
Yes, sir.
Yeah, here the testator must be the owner of the property. Yes, he should be the owner of the property. What is there? అత్తసొమ్ము ఎవరు దానం చేస్తారండి?
అల్లుడు.
వై దట్ అత్తసొమ్ము అల్లుడు ఎందుకు దానం చేయాలండి? So the property would be a person who has give the he should be the owner of the property when he wants to give it in the form of a will. The property must be capable of being transferred. Some property you cannot transfer it because it is not worthwhile to transfer. You cannot transfer, that's all. And some properties you can transfer it. But that property you cannot transfer, you are not the owner of it. So, and the property must be in the existence at the time of the testator's death. Yes. At the time of the testator's death, the property should be in existence. Suppose at the time of the testator's death, and he says, two bullock carts should be given to my daughter, but at the time when he died, the bullock carts are already sold because of the survival of the testator or medical treatment of the testator. That means that is not a valid will at all. Nobody could enforce it because when he made it, the property should be present. It is not necessarily that he should be in existence at the time of the making a will. Okay, the writing the will, not necessarily that he should be in front of him, but at least he is the owner of the property at the time, even though the property is not in front of him. Is it clear?
Yes, sir.
Good. So, any kind of property, mobile or immobile, corporeal or incorporeal, or tangible or intangible, is the subject matter of a will. Is it clear?
Yes, sir.
Yes, sir.
In order to be a valid bequest, the grantee's the bequest property must be a complete and absolute. The owner be testator. A bequest has to be unconditional, like a gift unconditional. If any condition is attached, say the legatee shall not alienate the subject of legacy, the condition is void. When you are given the bequest to your legatee, can you put the condition that you are not supposed to sell it? No. Once you given, that's all. Either he will sell it, he will spoil it, he will throw it if it is a mobile property. So legatee shall not be alienate. Alienate means sell. The subject of the legacy means the property which is going to get in the legacy. That is called the subject of legacy. The condition is void and the bequest is effective without condition. Because once you put such a condition and you give it, even the condition you put is a void, he can do whatever he likes. He can do whatever he likes. So likewise, a bequest in futuro does not contingent bequest. It is not a contingent say. It is a wagering bequest is there, that is the void. If the contingent means, say, let us see that how. However, an alternative bequest of the property that is no to one or failing him to other person is a valid. Suppose one person will fail to get it. Suppose the two members, can you give the property to the two members? Answer is yes. Can you give the joint legatee? Answer is yes. If one legatee dies, another legatee will take it. Is it or not?
Yes, sir.
A futuro is void, means he is going to get later part means void. But like usufruct, in the gift it is valid. But it is a will, but at the time of the will, when he died over there, the property should be in existence and he is the owner of the property. So, does so a contingent bequest. Contingent bequest also like bequest. At the time it is not there, but when he won it, when he got it and the contingent act is over, then he will going to get it. However, an alternative bequest of the property, alternative bequest of the property means to one or failing him to other person. Suppose one dies, two joint legatees are there. Okay. In the same manner, the subject matter is either the gold ring or the bullock carts should be given to the legatee. Suppose at the time of the gold ring will be given. At the time of these bullock carts the bullock carts are given. But both of the things are not there after the death of the testator. What will happen? Legatee is not going to get anything. Legatee is not going to get anything. But in case the gold ring is there and even a bullock cart also there, can the legatee will get two? Yes. Can the legatee will get the 2?
No,
Can
sir.
the legatee will get the 2? మీకు తెలుస్తుందని చెప్పండి, లేకుంటే మాకు అర్థం కాలేదని చెప్పండి. క్వశ్చన్
Pass on, sir.
పాస్ అని చెప్పేసి మీకు ఆయుధం ఉన్నది కదండి మీ దగ్గర, మౌనంగా ఎందుకుంటారు? See, I told you, there is a gold ring is there or bullock cart is there. The testator made it and testator is no more. But at the time of the testator, neither the ring is there nor the bullock cart is there. That means legatee is not going to get anything. Enduku? Because the subject matter is not in existence. But at the time of the will, it are there. That is one scenario. The second scenario is ring is there, but our bullock cart is not there. But they say or. They did not say and. They say or means any one. Okay, they will give the ring. If the both are present over there, can the both they will give to the legatee?
Yes, sir.
ఆర్ అన్నారు కదండి. నేను ఆర్ అంటే అర్థం ఏంటిది? ఇదన్నా కానివ్వండి, అదన్నా కానివ్వండి, రెండు ఇవ్వరు కదండి ఆర్ అన్నప్పుడు. అండ్ అన్నప్పుడు ఇస్తారు రెండు.
Yes, sir.
Now it is a choice of the legatee. Legatee says, no, I want the bullock cart. Okay, bullock cart will be given. The legatee says, no, I want the gold. Then gold ring will be given. But they say, no, they wrote first gold or bullock cart. First is available, hence I will give the first. Yes. He can insist also, who is administrator. Executor will say first return gold or bullock cart. But the gold ring is there, hence we will give the gold ring to you. So that is the only one they are going to get it, not the 2, because or is there. If the and is there, is both they are going to get it. And A and the and. Is it clear? So now then the testator willed that his son, if existing at the time of his death, will take the bequest. If not in existence, his son's will, and failing both, it will go to the charity. Suppose a legatee dies, then where the property goes? Did you understand the question first?
Yes, sir.
If the legatee dies, where the property goes?
Sharers,
Residuaries.
residuaries, distant kindred.
If the legatee having the sons, daughters, legal heirs will be entitled to get the bequest.
Yes, sir.
Yes, death will take the bequest. If the son is not there, existing at the time of the death, death will take bequest. If not in existence, his son will take it, and failing both, it will go to the charity. Son aitadi, sons aitadi. If it is not there, then it will go to the charity. Or it was held valid. So creating of a life estate is not permissible under Sunila. The bequest of life estate in favor of a person would operate as if it is an absolute grant. So sometimes, up to life interest, this man, life interest and then the 60 ఏళ్ళు బతుకున్నారు, 40 ఏళ్ళు ఇచ్చిన అనుకోండి, 60 ఏళ్ళు బతుకుతాడు. Means only 20 years that will keep with you. Of course, there is a calculations are there, only 2 lifetimes. Then it will end automatically. That we will see it later. Under Shia law, however, the bequest